Welcome back to the second segment of this law session on the structure of government. And of course, we were discussing previously and just before the break, we were looking at ministerial responsibility. So by way of recap, we considered the structure of government in terms of the office of the Prime Minister and the Cabinet. And what we looked at was that when you look at the Prime Minister and the Cabinet in respect of certain rules, conventions that operate in the context of ministerial responsibility, we see that ministers collectively, they stand behind the government, but individually, they tend to have certain responsibility they adhere to. And before I raised about the fact that there is this whole issue about their public life. So generally, if there's something that's gone wrong, again, the idea is that if you're a government minister, you really should fall on your sword, as it were. But what tends to happen in practice is that persons will wait and see exactly what happens. And then if it gets too bad or there's this backlash, then we see the resignations coming. Now, there have been, for some examples in recent times. So, for example, in 2010, we see David Lowes, who was the Chief Secretary to the Treasury. He resigned because he had claimed expenses for a property which belonged to his partner. And this was in breach, of course, of the rules, because the fact is, if you are an MP and you live outside of London, you are allowed to get certain expenses or claim certain expenses if it is that you have to get a place in London. But you can't claim the expenses, of course, if it is that the property belongs to you, family member, relatives, partner, and so on. And when we see, for example, something like this happening, then of course it is going to mean that such a cabinet minister will have to resign. Now, in 2011, Dr. Liam Fox, who was the defense secretary at the time, resigned over certain allegations which concerned the role of a friend of his, because Dr. Fox had this friend who appeared to travel with him at various times. He was apparently the best man at his wedding and all of this. But the problem came where the friend appeared to have represented himself as Dr. Fox's advisor. And as such, it created the impression that he was a formal government advisor. And this, of course, meant that from a personal life point of view, we see that his position becomes untenable. Now, when you look, for example, at a more recent type situation, we see the Lib Dem Energy and Climate Secretary Chris Housen, who resigned from the cabinet in early 2012 because it was announced that his former wife, Vicky Price, had basically taken points for him. Apparently, they were being prosecuted for perverting the course of justice because it appears that there were some charges which related to an allegation that Mr. Housen persuaded her to accept points on her driving license for a speeding offense which he actually committed. And of course, again, that appears to be a conduct unbefitting a member of the cabinet. Now, the decisive factor, as I say, would generally appear to be whether that cabinet minister continues to have the support of his or her party and the support of the prime minister, or sometimes you have to look on whether or not this minister has become a political liability. And so you do see that, again, there's this wait and see at times. The very recent example when we saw a wait and see, as it was Andrew Mitchell, who was the chief whip of the Tory party. And of course, I would refer you back to the previous law session on who whips are. But Andrew Mitchell was the chief whip of the Conservative Party, and apparently he sought to ride his bicycle somewhere through Westminster, and the police officers sought to speak to him about it. And apparently, or allegedly, he swore at them and allegedly called them plebs. And when you look at what had been done, he ended up, he waited a few days, and public opinion did not die down. And the long and short of it, of course, was that he resigned. But that, of course, would more or less be something in the context of personal life. When it comes, of course, to the other aspect of individual ministerial responsibility, which is how a government minister runs his department, what we have seen is that there has been a distinction being drawn between policy and administration. What I'm talking about here is what you get is this general idea or this general principle that if there is some untoward conduct or result from a government minister's department, then of course that government minister ought to resign. But what we have seen in recent times is that the government ministers tend to say, well, hang on a minute. If the result, which has been a disaster, has come about not because in my role as a minister it was disastrous, it was because of the government's policy taken at cabinet level, which I've had to go along with, then I ought not to resign because this was not about me. However, if it was to do with the administration, meaning how I as the government minister have run my department, then yes, I should resign. So when you look, for example, at some past situations, we see the former education minister, Estelle Morris, where the results for GCSE students were very poor. We saw that she resigned as the government minister because it does suggest some maladministration. And equally, Edwina Curry had famously gone on TV and as the agricultural minister had said something to the effect that she wouldn't eat eggs in England and Wales because they were full of salmonella or something along that lines. You're not going to want to say that if you're in that position of government. So the idea, of course, is that you see a shift. Now, there are several, and certainly when you look in the law books, you can pick this up. There are several situations where, for example, there have been the resignations or not, as the case may be. So when you look at, for example, the Mays prison riots, we've seen, for example, when there was a breach and that burglar managed to enter the Queen's bedroom. And when we look, for example, at various situations that have occurred, we have seen some situations the minister has resigned, and in others, we have seen the minister saying they are not. The point for you as a law student is to see why this has been the way it is, meaning there has been a shift by these ministers to draw distinction between policy and administration. Now, in the context of government action, one of the things that certainly the British are very well known for is to be able to open up an inquiry and to review themselves. So, for example, there have been several inquiries which have looked at various things. The Arms to Iraq inquiry, for example, was convened in order for there to look at whether certain decisions made at cabinet level were such that the persons who were apparently selling arms to Iraq, whether or not the government had a hand in it. There have been various other inquiries, for example, the Hutton inquiry, the Butler inquiry. The most recent one, of course, is the Chilcot inquiry. And we see that the Chilcot inquiry, which of course is still going on, and at the launch, we had the chair of the inquiry, Sir John Chilcot, setting out the inquiry's terms of reference. Now, most of these inquiries, if not all, certainly tend to take their name from the chair of that inquiry. And the Chilcot inquiry, we see that their terms of reference are that when the Prime Minister had agreed, for example, to go to war with Iraq, it looked at the period, or the inquiry is looking at the period between 2001 and 2009, and looking at the conflict in Iraq and looking at the military action and its aftermath. And it said that the idea of the inquiry was to consider the UK's involvement in Iraq, including looking at the way decisions were made, how actions were taken, and the idea of the inquiry is to establish as accurately as possible what happened and to identify the lessons that can be learned and to see if those lessons will help ensure that if they were faced with a similar situation in future, whether the government of the day is equipped to respond to those situations effectively in the interest of the country. So the idea of inquiries is to have a review and to see whether or not lessons have been learned. That said, sometimes the criticisms or one of the things that you have to look at in the context of inquiries is what do they achieve? Because, for example, when you look at the Arms to Iraq inquiry and when you look at the Matrix Churchill situation where we had these gentlemen who are being prosecuted even though the government knew the truth of the matter, we see that the result didn't come until years after, by which time it felt rather impotent. By the time you get the inquiry getting the results of the inquiry, the main players at either no longer are in government, it doesn't affect anybody anymore. I suppose the good thing about it is that it does stand as a documented framework, or it does stand as documentary evidence as to what was best practice or should have been best practice. But there is the criticisms at times that these inquiries achieve nothing. But of course, it is for you as the law students to make that sort of discussion in that regard. Now, as it relates to the government largely, I want to end off with the civil service. It doesn't generally come up on an exam as such, but you need to understand it in the context of the government. Because when we talk about the executive, the narrow meaning is the government, prime minister and cabinet. But the broader meaning, of course, is the civil service as being included. Now, there are three principles which underline the civil service: that civil servants are politically neutral, they're anonymous, and they're permanent. Now, when you look at the anonymity, we see that generally the idea behind the anonymity is that the government minister can't say, well, I didn't take this decision, it was done by a senior civil servant, because it is not the senior civil servant who runs the department. The point for us, of course, is that the civil service or the civil servants tend to have an air of neutrality. It is when this neutrality is compromised, and in recent times there has been a situation, and I would urge you to have a look at it, and certainly it's an easy Google idea, an easy search term on the internet, is to look at Dr. David Kelly. Now, Dr. David Kelly was a senior civil servant who, again, he was caught up in this whole Iraq war affair business. And it was his view that by and large, the basis on which the UK had subscribed and had gone to war with Iraq was not based on any substantive evidence as such. The problem, of course, was that there was this point of him having gone, or there was this allegation of him having gone to the media and to a journalist and saying something. Now, as a civil servant, that ought not to have been his remit. And of course, what we see in the end is this allegation of Dr. Kelly committing suicide. There is, of course, various conspiracy theories abounding, but as it stands, the idea was that Dr. Kelly had made certain statements, and as a civil servant, it really ought not to have been, in the context of the civil service, not for his to have raised. That by and large takes us through to the government. What we're going to turn our attentions to now, of course, is the House of Commons and the House of Lords. Now, before we go into that, what I want to flag up is what are the issues in relation to the House of Commons and the House of Lords? What is it that you need to take on board when you're considering these areas? Well, the two aspects that I want you to consider are these. Number one, when you look at the House of Commons, and certainly when you look at the legislature, it is about how it is comprised. And secondly, you look at its interrelation with the House of Lords. So what is the House of Commons there for? What is the House of Lords there for? And in particular, when we look at the House of Lords, the one thing that can ever be of any relevance to a law student as it relates to House of Lords is House of Lords reform. Once you know what it is, the only examinable issue is this whole issue of reform. We're going to take a short break, and as soon as we return, we will go straight into looking at the framework of the House of Commons, and of course, we will conclude in the final segment with House of Lords immediately after this break.